3 minutes for rebuttal. In this case, the judge of compensation claims denied claimant's claim for temporary disability benefits from January 23, 2016 and continuing based on Florida Statute 440-0933. That's the statute that states, in no event shall temporary benefits for a compensable mental or nervous injury be paid for more than 6 months after the date of MMI for the injured employee's physical injuries. And this court had 2 decisions, School Board of Lee County versus Huber and Utopia Home Care versus Alvarez, where this court held the limitation on the payment of temporary benefits for a compensable mental injury under that statute to 6 months after the date of MMI for physical injury is a calendar-based limitation and not a bank of time, that can be applied at any time thereafter. So in this case, the claimant reached physical MMI on January 22nd, 2016 with a 10% impairment. It wasn't until September 13th, 2016 that the claimant's orthopedic IME suggested that he needed to see a psychiatrist. Claimant saw the psychiatrist in January, 2 of them actually, 2 IMEs in January 2018. Both of them said that the claimant had a mental injury as a result of the compensable accident.
Was that decision on MMI incorrect? Should the judge not have entered that order, or should that order have been appealed? Or
Well, the claimant reached physical MMI on January 22nd, 2016. There's no dispute.
But MMI shouldn't be entered unless both are reached, correct?
We're correct. I mean, a claimant's not at overall MMI until the claimant's at MMI for both a physical and a psychiatric injury. But the way the statute reads is you're entitled to only up to 6 months of temporary disability for a mental injury, but the 6 months begin to run from the date that the claimant reached physical MMI. And in this case, the claimant's mental injuries wasn't even diagnosed and determined to be compensable until well after the 6 months expired. So based on that, the judge denied the claim for temporary disability benefits, which actually is in accord with applicable law at this point. But it's our position that the statute is unconstitutional as a denial to access to the courts for this claimant and other similarly situated claimants, because this claimant gets 0 temporary disability benefits for mental injury. And,
if this were only a mental claim, he wouldn't get
Beg your
benefits.
pardon?
If the injury here was purely mental, he wouldn't get benefits, would he?
Sure he would. I mean, if it was only mental, he would get some benefits, but I think the way...
If there's not a physical injury?
Beg your pardon?
I think the question is without a physical injury.
Oh, well, there has to be a physical injury in order for you to have a compensable mental injury.
Is your position that that statute's unconstitutional?
Beg your pardon?
Is your position that that statute's unconstitutional?
No, we're not even dealing with that statute.
I understand, but
I don't know. I'm not going to commit to myself right now, and that's not the issue.
okay.
I'm sorry. I mean, unless that affects this court's opinion in some way, shape, or another, but we're limited right here to 440-0933, which determines whether he's entitled to any temporary disability benefits based on his temporary mental condition. And it's our position that...
Okay, does it make a difference to your case? I know your position is that there's no competent substantial evidence to support the judge's finding that there was no no job restrictions based on his mental condition. But say we accept that, though. Does that make any difference for our analysis for Westfall?
No, because this court has had opinions that state that if you are not at overall maximum medical improvement because you're still not at MMI from a psychiatric condition, you're entitled to temporary disability benefits.
I know I dissented from one of those.
Beg your pardon?
I dissented from one of those.
Yes, you did. But that's what the court's ruling has been, though. You don't have, even if you don't have a mental disability, you're still entitled to temporary disability benefits based on your physical limitations and restrictions until you reach overall MMI, which includes MMI from a psychiatric condition.
Was the MMI that was in 2016, was that limited by the order? Was that not overall MMI at the time?
Well, at the time it was, because
Okay.
he only had physical injuries.
So he was at overall MMI, and then subsequently he fell out of being at overall MMI.
Yes, when his temporary disability benefits were considered compensable, or excuse me, his mental injury was considered compensable. But here's the access to courts provision, the law on that is that the legislature can't take away a benefit that a claimant had in 1968 unless they give a reasonable alternative or they show an overwhelming reason for doing so. In 1968, there was no restrictions on on a claimant's ability to get temporary disability benefits based on a mental injury, other than they could get it for up to 350 weeks. And temporary partial disability benefits back in 1968, you could get up to 260 weeks. It said 5 years in the statute. Then in 1990, the legislature reduced that to 260 weeks for temporary disability, and the Scanlon court said it was not a violation because it still, it was pretty many benefits, et cetera, et cetera. But then Westfall came along and said going down to 104 weeks from 350 was a violation of the access to courts provisions because you got past the tipping point to where the benefits were pretty minimal and it didn't constitute a reasonable alternative. Well, this statute not only reduces the temporary disability
Well,
benefits.
isn't it sort of a line drawing thing? Because if this psychological injury would have manifested itself in 2016, then he would have gotten 260 plus 6 months, as I understand. So it's more of a, unfortunately, he falls out of the window for which the line's drawn by the legislature in this instance.
It wouldn't have been 260 plus 6 months. The 6 months is included in the 260.
Okay.
But, you're correct. If his psychiatric injury had manifested itself before or at the very time that he reached physical MMI, then yes, he could have gotten 6 months temporary disability benefits. But unfortunately, it didn't, and a lot of them don't. It takes a while sometimes.
Okay, I'm going to follow up on Judge Osterhouse's question. The fact that he got 260 weeks of temporary benefits, would that kind of put this more in the Martinez versus Scanlon gambit versus the Westfall gambit?
Well, he didn't get 260 weeks of temporary disability benefits in this case. He only got about 31 weeks, as I can figure. So this statute, but the point I'm trying to make is that 440-0933, when it was passed in September 1st, 2003, what it has done to this claimant, it has precluded him from getting any temporary disability benefits for his mental injury, whereas before that statute was passed, and back in 1968, he could have gotten up to, 350 weeks in 1968 and 260 weeks effective 1990. So they've
The
cut out.
situation is different than Westfall, right? Because in Westfall, there was no permanent benefit. The person couldn't work, and he wasn't receiving anything. Here, there was a permanent benefit paid. He can work. So it's a different situation than Westfall. Westfall was about taking down a statute because there's a dramatic problem here. I hear the problem that you're explaining. It seems like it's a problem that's going to hit some people, but it's not some people who can work, but it's not of the scope of a Westfall type case.
Well, actually, I think this case, and I understand what you're saying, but I think this case actually is even more compelling as a violation of access to the courts, because in Westfall, it was a reduction of temporary benefits from at first 350, then to 260, and then to 104, and the court goes, okay, enough is enough. In this case, they've completely taken away his entitlement to a temporary disability benefits based on his mental injury. Whereas before that statute, he could have continued to get temporary disability benefits for, now up to 260 weeks based on the Westfall decision and then the two decisions from this court regarding temporary partial disability benefits.
Now, going forward, this appellant's, he's receiving care from the employer, and he's also got a
Yes.
permanency rating, and that I
Yes.
guess could be increased on the basis of his psychological impairment if the situation called for it. Is that
Yeah, but I can't remember right now, but I think
this statute
Doesn't
this statute is about temporary benefits. It's not about restricting
Right.
permanent benefits.
but even for permanent psychiatric benefits, I think there's a very small percentage that they're entitled to. But I don't know, it just seems that when you pass a statute that keeps a claimant under these facts, and these are not unusual facts, from getting any temporary disability benefits, when back in 1968 he could have gotten up to 350 weeks worth, there's a problem, and it's a violation of access to the courts. And I do want to go back. The question you asked me is, do I think it's unconstitutional if you have to have a physical injury in order to have a mental injury? I'm not saying that it is or isn't, but I've always thought it was unfair sometimes. What about the situation where a bank teller has a pistol put to their head? There's no physical injury, but anyone who says that doesn't create a mental injury, it's just not realistic. So I really wonder sometimes about situations like that, but that's not the issue here. So I guess I'll reserve the rest of my time for rebuttal.
Okay, thank you.
May it please the court, Your Honors, Steve Preston for the appellees, Lincare and Travlers. We believe that the statute the statute is constitutional and should be upheld, just like the many other workers' compensation statutes that this court and our Supreme Court have consistently upheld for decades, where there were limitations or qualifications for eligibility to get a certain benefit. And one of the key points that distinguishes this situation, this statute and this case from Westfall is that Westfall was talking about someone who was cut off from any benefits whatsoever arbitrarily by the reduction down to 104 weeks, and they were worried about somebody not getting any benefits at all for what could have been a really extended period of time. And that was for physical injury. Physical injuries, within course and scope on the job, they're always compensable. This court expressly recognized in the Alvarez decision that mental injuries, compensation for mental injuries is distinctly different, which is why it has been never challenged that I know of that you can't get compensation for...
Let me understand. So your main distinction between this and Westfall is in one case we're dealing with mental injuries, and in this, physical injuries. In one case you're dealing with mental injuries?
Partially, Your Honor. I see it as a twofold thing.
Okay, well, that's one. Okay, explain the other one to me.
Yeah. The first is that difference. The second is that in Westfall, you would have this complete gap where you wouldn't get any benefits at all. That's not what happens here in this case or with the statute in general. The statute proceeds from the point of it being an exception to the general rule that you don't get psychiatric disability benefits. There's a limited exception to it, and the legislature has drawn that line or redrawn that line at 6 months from the date of physical MMI.
But you're not getting benefits after that time. I'm really having a little trouble distinguishing. It sounds like you're going back to the difference between physical and mental injury as part of your second point. And that's where I'm having a little trouble.
Well, that's why I expressed it as twofold.
No, I understand. I understand the first point, physical versus mental, but I'm having trouble understanding the distinction here that you're making. Aren't benefits totally cut off here?
Well, they were not, Your Honor, and if I may explain.
No, that's what I'm going.
A couple of things. First, this claimant and any others similarly situated through the date of physical MMI could get and did get the temporary indemnity benefits based on his physical injury. after the date of MMI, if he qualifies by the other statutes, the statute on permanency, he can get permanent indemnity benefits. And this particular claimant and any other similarly situated can, and in this case did, receive psychiatric treatment. So there's not a complete cutoff of psychiatric benefits or benefits at all after that physical MMI date plus 6 months under the statute. He can continue to get his psychiatric treatment.
You can get the permanent indemnity benefits even though he's not at overall MMI?
Well, he's at MMI as of January 22nd, 2016, so he can get the permanent benefits. There's been no change in the MMI date. And again, he had gotten previously surgery and post-surgical care. He had gotten his temporary benefits based on the physical injury. If he qualifies, then he can get permanent benefits because of his physical injury, and he gets the psychiatric care for his psychiatric injury.
Okay, let me go back a second.
Yes, sir.
If his psychological condition had manifested itself prior to him reaching physical MMI, though, or within that 6 months, or let's say before he got physical MMI, then his benefits would be cut off at 6 months?
His temporary indemnity benefits based on his psychiatric injury would be cut off no later than 6 months.
But he couldn't get him permanent impairment benefits because he would not have been at overall MMI. It's only because of that the psychological condition manifested itself after he was at physical MMI, was he able to get permanent benefits? If it had manifested itself before, he could not have gotten permanent benefits.
If it had manifested before, I mean, ultimately, if he otherwise qualifies for permanent benefits, he'll get the permanent benefits.
If he's not an overall MMI?
No, if he is deemed to be at MMI, then he can qualify for permanent benefits.
Okay. If I have physical and mental injuries, and too many statutes, too many years on the bench, I'm trying to figure this out. Physical and mental injuries that cause disability. He reaches physical MMI, but he does not reach psychological MMI. I thought the case law, but I could be wrong, but I thought the case law said you had to be at both physical and mental MMI in order to get permanent benefits.
I don't believe, well, in this case, he was not given an
No,
MMI.
I understand. I'm just trying to understand the context.
In the general, yeah.
Okay.
There's only, the concept is MMI, right? There isn't physical MMI, mental MMI if you have both injuries. You're going to reach MMI.
Well,
correct? And either you're there or you're there in both areas or you're not.
well, that's not how I read this court's decision in Alvarez, quite candidly, Your Honor. I read this court's decision in Alvarez and the prior decision in Hubin as stating that, using the term physical MMI date and saying that starts the clock.
Would it be an error for a court to enter MMI if psychological injuries continued?
If there's psychological injuries that have already manifested, the court should not be entering an MMI order. That's what y'all were getting at.
Yes.
My apologies for not getting to it sooner, Your Honor. Yes.
Okay, I'm trying to understand the statute here then.
Well, and the statute.
So
Sorry, Your Honor.
if you're physically well, don't you only have 6 months of psychological impairment? Because
You only
it
get
seems to me that the statute itself is talking about physical MMI.
The statute
So-
is definitely just talking about the physical MMI. It's drawing a start date and giving you a 6-month clock.
So help me, because I
And that's
really
where
want to
that-
try to understand this, because I'm getting more and more confused the more I talk about it. if I have a physical and a psychological injury, and physically I'm totally good, no problems anymore. But the court cannot enter an MMI date because mentally or psychologically I've not reached maximum medical improvement. When does the 6 months start to run? If you can't enter an MMI date. I mean, it seems to me that the statute contemplates that you can get well physically and still have a mental problem. And even if you get your 6 months of your mental benefits, and they cut off the temporary benefits, but you can't get permanent benefits because you are not totally an MMI. This case is a little bit different because you're already determined to have permanent impairment benefits. But isn't it exactly kind of like Westfall under this statute where your permanent impairment benefits don't kick in? I mean, the situation I'm describing.
The situation you're describing, Your Honor, gets closer to Westfall. But it goes back to what Your Honor asked me about earlier about my position being twofold on the distinguishment with Westfall, because there's a very limited exception to the general rule of non-compensability for these mental injuries. And the legislature wants it to be close in time.
I understand that part. But there's the potential of somebody not being an MMI, their benefits cutting off after 6 months, and not being eligible for permanent impairment because they're not at psychological MMI.
Well,
permanent impairment benefits.
Well, they still have the physical if they qualify for the permanent impairment. They had to have had the physical, otherwise they couldn't have had the mental in the first place on any basis.
Okay, but can you get permanent benefits unless you're both at physical and mental MMI?
Well, if you're unable to work, which is not the case here with this claimant, but if you're unable to work, I don't see why you wouldn't be able to get your permanent benefits. Or extended temporary under Westfall for if you're not at MMI and you have the physical injury, then that is the link you get to get your temporary indemnity benefits for. You still have a temporary impairment.
And that's the situation of the appellant here. He's gotten permanent benefits and he's at MMI.
He was declared at MMI. He's not losing anything.
I'm just trying to figure out how this statute works. I understand here he's got the permanent benefits.
Yes, and in other cases, one may not have the permanent benefits, but if you're not declared at MMI, you've got, under Westfall, you have the 260 weeks for your physical, which far outstrips, as counsel for appellant pointed out in his presentation quite correctly, that far outstrips the 6 months. 6 months, only 26 weeks. You literally get 10 times as much for the physical as you do for the mental. And that's, as this court said in Alvarez, is within the legislature's province to draw a line like that. And it's still a reasonable alternative to torts. Remember, this claimant and any others similarly situated, or even a claimant in Your Honor's hypothetical, is getting benefits which can be debated as to which ones he really should get or how much he gets, but he's getting workers' compensation benefits without having to prove fault on the part of his employer or any other third party. It's much less time-consuming, and it is much less expensive, and he gets an attorney paid for, which he would not have in tort litigation.
Westfall said, you get all that, but there's still a point you can cross by cutting off benefits.
Yes,
that's not a reasonable alternative anymore.
And that's what Westfall, of course, Your Honors, dealt with, was saying that there is the point that we're going to say it's too drastic a reduction. And the court said, and the Supreme Court of Florida said that going down to 104 weeks of of temporary indemnity benefits for physical injury was drawing that line too short, and that if you don't have the physical injury, then you could be in a situation of getting nothing until you reach that MMI date after you've passed 104 weeks. And the Supreme Court of Florida said, well, that's too long a gap. We're not going to let people have nothing for that long a period of time who have a physical injury. But here we have the more limited exception to the general rule of non-compensability that they don't have on the physical injuries that Westfall dealt with. And that's what I see as the most key distinguishing feature. You know, the starting point is in Westfall is physical injury, you're getting benefits. The starting point here is mental injury. You don't generally get benefits. For example, you don't get them at all, as your honors pointed out earlier, if you have a purely mental injury. Even in the hypothetical discussed with counsel for appellant about that he brought up with somebody working at a bank getting a gun put in their face. If that's all that happens, if there's no physical injury, they get 0. And that's always been the case, 0. And if that's okay, then certainly in this case, and others similarly situated, it's not a denial of access to the courts if, besides all the other benefits you get, without having to go through the risks and having to prove fault and the costs and the delays of the tort-based system, it's still appropriate as an alternative to that system to have the benefits that we have in the workers' compensation system. And again, it's very limited on mental. That's the starting place. Very limited, but we'll give 6 months for temporary from the date of physical MMI. And that's how we see it, Your Honors, and we feel that this statute should be upheld like so many others that, for example, cut off benefits at age 65, like the Sasso case and things like that. It's no different.
Thank you, counsel. Mr. McCabe, let me ask a question, as I want to do. Okay, it seems to me that the major distinction that is being made here between Westfall is that this person is getting permanent benefits, where in Westfall couldn't get permanent benefits because it was not an MMI. Isn't that a valid distinction between this and Westfall?
Well, I think in this case the claimant's getting nothing for temporary disability benefits based on a mental injury. They've completely taken that right away, which prior to the passage of this statute, the claimant could have gotten it for up to 260 weeks now. It's completely doing away with a cause of action. Now, the case that says that I cited for you're not at overall MMI until you're at overall MMI or MMI from both the physical and psychiatric injury, one of the cases is that Grieber versus Tallahassee Development Center, which is cited in my brief. And then the two cases that say you continue to get temporary disability benefits, these are pre-October 1, 2003 cases, that you continue to get temporary disability benefits until you're at overall MMI, even if there's no psychiatric restrictions, is Sapp versus Berman Brothers and Rojas versus United Sheet Metal, which I cited, and the Rojas one's the one where you dissented. Here's how I interpret the 440-0933 statute, is if you have both physical and mental injuries before you reach overall physical MMI, and then you reach physical MMI, you can continue to get temporary benefits for another 6 months based on your psychiatric injury. And then I think you raise an excellent point that what happens at the end of that 6 months if you're still not at overall MMI? Can you then get permanent disability benefits, permanent total disability benefits, or do you have to wait until you reach overall MMI? So that's a really good point, but that's not where we're at in this case.
That's not this case. I mean, but I was trying to understand it in my mind.
And in the Hubin case, which was the first case where this court really said that the 6 months is a calendar and not a bank of time, the claimant only ended up getting like 8 days of temporary disability benefits because they didn't determine that he had a mental impairment until about 8 days before the 6 months calendar had expired. In the Utopia Home Care versus Alvarez case, which is the one that they took to the Florida Supreme Court, but the Florida Supreme Court decided they didn't want to accept jurisdiction. It appears that the claimant challenged on constitutional grounds the length of the 6 months. And this court said it was premature because in that case, there was only 3 months before the claimant, from the time physical MMI to psychiatric MMI. In this case that you have before you now, our argument is that based on the facts of this case, this claimant has no cause of action for temporary disability, or excuse me, temporary mental health disability benefits. Zero, none. It's completely eliminated. And those cases, even they cited them in their brief, and all the cases about access to the courts say that if a cause of action is abolished and nothing is, a reasonable alternative is not presented, it's a violation of the access to courts. And under the facts of this case, this claimant's right to temporary mental health disability benefits is completely abolished by the passage of that statute on October 1st, 2003. So it just seems to me like it's a violation of the access to courts. And I think the remedy is for it to go back to before the statute was passed. Thank you.
Thank you. Be repetitive. Excellent oral arguments. Thank you.
Thank you.
All right.